I found out what he had done on a Saturday morning when a supplier emailed me to confirm the transfer of our account to a new company. I did not recognize the company name. I called the supplier back and asked them to send me the transfer request they had received. It had been sent from my business partner's email address. It referenced a company registered 4 weeks earlier. The company name was similar to ours. The director was him. I sat with that for a while. Then I called our solicitor. Marcus and I had built the business over 6 years. A specialist training and consultancy firm, 17 clients, 4 employees, solid recurring revenue. We were equal partners, 50% each, documented in a properly executed shareholder agreement drawn up by a commercial solicitor at the start of our partnership. The shareholder agreement contained, among other things, a non-compete clause. Neither partner could establish a competing business without the consent of the other. Neither partner could solicit clients or employees. And neither partner could transfer company assets, including client relationships and supplier accounts, without board resolution, which required the agreement of both directors. He had done all 3. The picture that emerged over the following 72 hours was methodical and deliberate. He had registered the new company 4 weeks earlier. He had begun approaching our clients individually. I found this out when 2 of them called me, confused about correspondence they had received asking them to update their supplier details. He had transferred our primary software license and 2 supplier accounts to the new entity. And he had, I discovered from one of our employees who called me directly, offered positions at the new company to 3 of our 4 staff members. He had been planning this for months. I did not contact Marcus directly. My solicitor advised against it. Anything said between us at this stage could be used in proceedings, and it was better to act first and communicate through legal channels. We applied to the court for an emergency injunction the following Monday. The injunction application cited breach of the shareholder agreement, misappropriation of company assets, and breach of fiduciary duty. We sought an order preventing him from continuing to operate the new company in a capacity that competed with ours, from further soliciting clients or employees, and from continuing to use the transferred assets. The injunction was granted on a without notice basis, meaning he found out about it when it was served, not before. This is unusual but justified where there is evidence of ongoing harm that would be worsened by giving notice. He had until the return hearing, 5 days later, to respond. At the return hearing, his solicitor argued that the shareholder agreement non-compete clause was too broad to be enforceable. This is a standard argument in these cases, and not always wrong. Overly broad non-competes can fail. But ours had been drafted specifically and carefully. It was limited to 18 months, limited to our specific service areas, and limited to clients we had actually worked with. It was, our solicitor argued, exactly the kind of narrowly drawn clause that courts routinely uphold. The judge agreed. The injunction was continued pending trial. He had no realistic path to trial. The documented evidence of his conduct, the company registration date, the client approaches, the asset transfers, the employee solicitations, was comprehensive and largely in writing. His solicitors advised him to settle. Settlement negotiations took 6 weeks. He transferred the new company's assets back to the original business. He paid compensation for the clients who had been approached and the disruption caused. He resigned as director. His 50% shareholding was purchased by me at a price reflecting the damage his actions had caused to the business. He is no longer in this sector. The business is smaller than it was. 2 of the approached clients left regardless, spooked by the disruption. But it is mine. The 3 employees stayed. The recurring revenue is stable and growing. I rebuilt. He didn't. If you're in a business partnership, read your shareholder agreement. Make sure the non-compete, the asset transfer clauses, and the dispute resolution provisions are specific, current, and properly executed. It is the most important document you'll ever sign. Has a business partner or colleague ever tried to use access against you? Drop it in the comments. And if you want more complete stories with no part 2s that never come, follow the page. New story every day.